Hi, this is Alex Stepien for Trademarkia and welcoming Nancy Molokwu. How are you doing, Nancy? How are things in your neck of the woods?
Hi, Alex. I'm fine. How are you doing?
Great, great. It's a nice day outside. The weather's warm in this part of the world in Central Eastern Europe, Warsaw. Where are you joining us from?
I'm joining you from Lagos, Nigeria. The weather here is great. It's the rainy season here, and it just rained this morning, but right now the sun is out. It's cool right now. Everything is great.
Fantastic. Nancy, having worked with us for nearly 2 years, what are the key benefits you've seen for businesses employing a legal service like Trademarkia?
Well, I would say that Trademarkia offers multiple benefits, ranging from expertise to support and guidance for any of its clients. With regards to expertise, I would say that Trademarkia have over 50 licensed attorneys from different jurisdictions or countries. And these attorneys are top-notch legal attorneys who have years of experience, so they can offer quality legal advices and sound opinions for any of their clients. Also, in terms of guidance and support, I would say that trademark attorneys are number one when it comes to that. They will carry you every step of the way, and you'll be rest assured that you have peace of mind when you go home, knowing fully well that the legal services of your company or your business is going to be sorted out by trademark. In addition to carrying you along, I will also say that trademark also have a cost saving package for its clients. Whether you are a small business, a startup, a small medium enterprise, our fee package is something that any organization can afford. It is not something that is going to shock a startup company, for instance. They have different packages, and this package also, like I mentioned earlier, the services to be delivered are top-notch quality services. So choosing Trademarkia is a wise decision for any business holder, for any organization, and for any individual.
Fantastic. I couldn't agree more with what you said. Nancy, if a business suspects their intellectual property rights may have been violated, what immediate actions should they take?
Well, as an attorney, I would advise that they should first hire the services of an attorney because a lawyer knows it all. A lawyer knows how to handle such things. A lawyer knows to send a cease and desist letter to the infringer because most times these infringers might not know that they are infringing on your brand. So getting a letter from an attorney will kind of put fear on them. And in situations where they know that they are infringing, getting a letter from an attorney will also make them to back out. So my first advice is to engage the services of an attorney. An attorney will know the steps to take
Sure thing.
and
Have you
whether to pursue in court. I'm sorry, I just wanted to mention that an attorney will also know whether to take legal actions too after serving a cease and desist letter.
have you experienced in your professional career any situations, worst case scenarios? Have you actually seen people who have actually been too late? They didn't decide to engage proper legal representation, and then they had to bear the brunt of their bad decision.
Yeah, multiple times I've experienced that in the course of my practice. I know a case in issue, one of our clients that could not take the legal steps of, taking the legal steps or engaging the services of a lawyer, and it eventually even led to the point of the infringer taking steps to register the trademark in question as if the trademark belongs to him. So it eventually went to court, and at the end of the day, although our client succeeded, but it was a pain in the ass for the client to get that judgment because if he took the initial steps, I don't think the client would have spent all the resources that he spent in court to get that judgment in his favor. It was a lengthy litigation, but at the end of the day, the client was able to succeed.
Fantastic. So, would you say this was a case of patent trolling or trademark trolling?
It was a trademark trolling. That was the case at hand.
Interesting, interesting. What are the best practices for businesses to monitor and enforce their intellectual property rights effectively?
So one of the ways I would suggest for any business to monitor their intellectual property rights is first of all to conduct routine market search. Yes, this can be vigorous, but conducting a routine market search will help you to know whether your competitors are actually copying an identical or confusingly similar trademark as yours. In addition to that, we know we are in the digital age, and there are chances too of um the other party, like the third party or a competitor who sells their products and services online, also infringing online. So you can conduct a monthly e-commerce search too, with the aim of identifying whether something similar to your mark is being sold online too. In addition to that, I will also recommend conducting watch service, and that is where a legal practitioner comes in, because a lawyer is the one that will help conduct this watch service. So what service basically entails when a trademark journal for a particular country is being published. The legal attorney in question will help you to look out for any mark that might be confusingly similar or identical to yours, and the lawyer will inform you. So watch service, market search, and e-commerce search are the three recommendations I make for any business owners if you want to look out for your trademark.
Thank you for that answer, Nancy. So, another question: why should a business owner register their trademark in the U.S. and internationally? Because most of our business is in the United States. Nevertheless, we're an international company with a lot of people working for us. A fantastic team at a real international law firm. So, have you had experience working in transnational operations?
Yes, a number of times I've assisted clients to file their trademarks in Canada, United States, the United Kingdom. The list is so long, Mexico. In fact, Trademarkia has exposed me to handling matters like that, and I'm grateful for that. So one of the advices I will give to clients, especially startups, is to consider protecting their intellectual property rights. Having just an idea does not guarantee you that you have a right. An idea is just an idea until it is protected. That's when your right can start. So protecting your intellectual property rights will grant you the exclusivity to the use of your trademark or patent or whatever it is you have protected, because there are different intellectual property rights. So you have that exclusivity, and with that right of exclusivity, you can ward off third parties that are trying to use your brands in an unauthorized manner. In addition to that, you can also bring an infringement action where you have a right. Because when you don't have a right, you now have to prove common law thoughts of passing off, which is sometimes difficult to prove. But with a registration, with your right and a certificate at hand, you can actually bring an action. Also, it adds asset value, because when you have your brands protected, you can be recognized by your consumers. When consumers go to the market to purchase something, they will identify your product and associate you with it. So, in addition to that, I will also say that having your brand protected also helps you to generate more revenue, because at some point when your mark, for instance, your trademark becomes well known, you can actually license it to other companies to use, and you are going to generate revenues from it. So the importance of having your intellectual property rights protected can never be overemphasized. In fact, it's very important. If you want to reap the economic benefit of your intellectual property rights, you should take steps to protect it. Please hire a lawyer today.
That sounds like great advice. Tell me more about these transnational operations you've been involved with, of course, to the extent that you're allowed to, because this sounds like a really interesting business proposal for companies, for businesses expanding their potential market share.
Okay, I've had a client from the United Kingdom who also offers services in other country. Sometimes they feel like protecting their trademark in the UK will just protect them, but what they do not know is that trademark registrations are territorial. So the fact that you have trademark protected in the United Kingdom does not mean that that right extends to, for instance, Nigeria or Canada. You have to take steps to protect them in those other countries. So I remember the client came with protecting their mark just in the UK. And after successfully registering that trademark in the UK, I went through their website and I saw that they actually offer their services in other countries. And I wrote an advisory in advising them on the need to extend their protection to those other countries. And good thing, they were happy because they didn't even know. They thought that that protection in UK was just enough. So they took steps to also extend their registration to Canada, to Mexico, to the United States. And currently, they have obtained registration certificates for two countries. One is just still pending because of the opposition state. Not like the mark was opposed, but it was published. So you have to give people chance to actually oppose if they want to. So that is one of the experience that I have. Um, there is also another client of mine too that is considering registering World Intellectual Property Organization registration. This WIPO application, also known as the Madrid Protocol, is one application that allows you to also seek protection in member states. So for all the member states in the WIPO, if you designate that you want to extend your protection, it covers those other member states. So you don't need to go to national filing, do national filing like registering your trademark in one country, going through that can be money consuming. But with WIPO, it's more cost effective because it's like killing three birds with one stone. You can file one application, and that one application will extend to other member states.
For American viewers, let's just say that we're talking about the European Union's Agency for Intellectual Rights Protections. Did I say that right?
Yes, there's also a filing for the EU. One application will also cover you in other member states of the European Union. Yes, we have that. We also advise clients to, especially when they offer some of their services in the EU countries, we just advise them to also seek protection in the EU.
All right, Nancy, thanks for that. So, tell me, like, if you tried to divide the businesses you deal with into industries, are there any particular industries where you see the greatest need for trademark registration and protection?
Yes, I would say the fast moving consumer goods industry because these industries they keep producing on daily basis. Sometimes they even like get lost of the marks that they need to protect. So it's left for you as an attorney to keep advising them, to keep making recommendations for them. Go to their website, look out for new brands that they have brought into the market and advise them on the need to protect this mark. Tell them the benefits, give them the classes because sometimes they feel like the goods fall under one classification. It's left for you as an attorney to look beyond just one classification and advise them on the need to extend.
Pardon me, Nancy. So, for some of our viewers and listeners who don't know, what exactly classification are you talking about right now?
I'm talking about the NICE classification. It's just an administrative way that WIPO has actually brought out for goods to and services to be classified. For goods, we have classes 1 to 34. Then for services, it's from 35 downward. So it's just basically the way of arranging the registrations for administrative purposes.
What are the top brands that you know that have been sold or that you've actually participated in the sale of brands or trademarks?
Well, because of confidentiality purposes, I'm not going to mention names, but I have also been part of the teams that actually sold a big brand of intellectual property rights. Like there was an assignment of their trademark to another industry, and there are instances where they also acquired some companies too, and we had to file recorder of assignments for them and all that. Yes, I've participated in that.
So, could you maybe highlight the challenges and the benefits of these processes you were involved in?
Okay. So the benefit is that, of course, you are gaining more brands, you're gaining more brands, and that is more money for the business. Then, some of the challenges that I faced in the course of that transaction was the back and forth with the assignment agreement, because sometimes the parties will have issues with some of the clauses in the agreement. At some point, they won't even want to go ahead anymore because of some issues with agreeing on what not to keep in the agreement. But eventually it was a successful one. So I would say that the best approach to it is just to be patient, understand what the other parties want, see their own view, understand their own view, and be able to convince them. If you are not okay with that, you don't need to make an issue out of it. Just listen and, of course, protect the interests of your clients always.
What unique considerations should startups and small businesses keep in mind regarding intellectual property protection compared to large corporations?
For startups, they need to bear in mind that when sharing their idea with any organization or any person whatsoever, that they need to have an NDA in place. An NDA is a non-disclosure agreement. That way, you are sure that the idea you are sharing with anybody is not something the person is going to steal and go away and make it big for himself. So you need to protect yourself. You need to protect yourself by entering into an agreement before disclosing. Because for an idea, it's just an idea until you have taken steps to protect it. You don't know if the third party you are sharing it with is someone that is also interested in delving into that business and they can just take your idea and sell it for themselves. Secondly, for companies, let's say that a group of people were the ones that came up with the whole idea, there is there is need for you to clearly stipulate the one that you came up with. So if there should be an assignment agreement where everybody's right is being stated, so you will know the one that you came up with to avoid issues. Because I know that in some employment contract, they say that the intellectual property rights that an employee actually came up with in the course of employment belongs to the employers, except there is agreement to the contrary. So in such situation, you need to specifically stipulate the ones you came up with so that in the event you leave the services of that company, you will know that this right belongs to you. You are taking it along. And if you want to sell it to the company, of course, you will know what you are selling and all that. Then, in addition to that, I will also advise startups that even though the steps to protect an intellectual property right might take time, they should make sure that they exercise that patience and go ahead with protecting, because the long-term goal, the long-term value that you get from having an intellectual property right is worth it. So exercise that patience, engage the services of an attorney. You don't have to do it yourself at times because there are some technical things that a lawyer only knows how to handle and not you. So always engage the services of a lawyer and you are good to go.
Thanks. So, would you say that for startups, there's like a specific time frame? What's the best time for a startup to hire a law firm to protect their rights?
Immediately you have that idea that you feel is going to boost your business to go, then just hire a lawyer, hire an attorney instead of sharing it with a non-legal person who might steal your ideas. Because automatically, the moment you hire a lawyer, the client lawyer relationship has already started. So you know that no matter what, your lawyer is not going to steal or breach the confidentiality that you share. So I would say once you have the idea and you are ready to kickstart it, by all means hire a legal practitioner.
Indeed. From the perspective of the year 2024, would you say there's a greater need for intellectual property right protection than in the past?
I would say yes. Yes, that my answer to it even last year would have still been yes, because the importance of protecting our intellectual property rights can never be overemphasized. Even with the new digital age that we are in, it is even more important to take steps to have your intellectual property rights protected. Because if you do not protect it, how sure are you that before you are ready to take steps that somebody else have not taken that idea or come up with something slightly similar to yours, and it will now make yours not to be novel, especially in situation where it's patent, for instance. So yeah, I would say in 2024, everybody should have their intellectual property rights protected. Nobody has time for lengthy litigation of trying to prove that you are the actual owner when you can just tender a certificate to show it proves it all that you are the true owner of the IP rights in question.
Would you say that there are certain regions where there is a stronger activity of patent and trademark trolls?
Well, um, I can't really say for sure, but I know that in Africa, we have cases of infringement quite a lot and piracy, which we have been trying to tackle, but it's not something that is easy to come by. Like, it takes gradual steps for us to get there. But I'm not going to specifically call one country or the other, but I know that infringement cases happens a lot in almost all parts of the world. But I'm talking about Africa now because I'm from the continent. I know that we have a lot of cases of infringement, piracy, copyright infringement and all that. And legal practitioners in the intellectual property field are trying as much as possible to sensitize the public, sensitize the business owners on the need to know, on protecting their brands, on protecting their intellectual property rights, and the ways to enforce it in situation of such breach. So
All right. How about IT? Is this a bigger danger or less of a danger regarding startups in the field of new technologies, other than fast-moving consumer goods, as you mentioned before?
I would say yes, because the internet, in as much as it has its benefits, which is to help disseminate information, you can publicize your IP rights, your works, especially your copyright works. It also has its own downside in the sense that anybody can just go ahead and start sharing your intellectual property rights without your permission. And most times it has the effect of making the creator not to reap the economic benefits of that work. So I would say that's the downside. And right now, I won't say that we have enough laws in place that actually seeks to protect such creators, especially when their work in the digital space is being infringed. I know that steps are being taken to enact some laws to protect them, but you then I feel like the digital space has its pros and cons, especially for the creators.
Do you believe artificial intelligence poses significant risks to intellectual property? And if so, what are these risks?
Well, I would say yes, if not properly protected. Yes, because I know that artificial intelligence can generate people's voices, can generate images, and I know a recent case of an actress. I'm trying to remember her name. Joacine Scarlett, yes, Joacine Scarlett, where OpenAI actually generated her voice without her permission, and they were just trying to make money from it. In such situation, I feel like artificial intelligence has come to kind of take the place of humans in the sense that the economic benefit that ordinarily the the creator is supposed to pay the artist in question, they're trying to evade it by using AI. So it rips off creators of their own copyright work or their own intellectual property rights. On the other side, I will also say that AI has also come to play a good role in our society today because with AI, sometimes if you come up with a name, for instance, I want to create a business name and I come up with a name, with ChatGPT, you can actually check if that name is available. So you know what you are dealing with. In situation where it is available, you will know that you have to come up with another name. So it has its pros and cons. But whatever it is, I just believe that if properly regulated, everybody can benefit from it and nobody will suffer. The creators will not suffer. At the same time, those that are into the whole AI will still have their own benefits and everybody will be happy.
Nancy, all right, since these are the strict questions, the ones they had written down in my book, but tell me about your legal career and how did you end up focusing on a trademark and intellectual property right protection?
Wow. So, of course, I graduated in 2014 from the University of Nigeria. And when I was in my second year, there was this particular course that was offered, Law of Consumer Protection. I was so in love with that course. Like, it was an elective. When I was even electing it, I just elected it based on the name Consumer Protection. I just felt like it would be an interesting course. But, going into it, I realized that, oh my God, this is an area of law I would actually like to specialize, because it was in my fourth year that intellectual property was introduced to us. So I didn't know there was an intellectual property law as a subject. So in fourth year, intellectual property law was introduced, and I'm like, this is the area of law I'm going to specialize in. So my first law firm where I started my career in was an IP law firm. They were like number one in Nigeria. So it helped to groom me. I saw different areas of intellectual property law and I was happy to do it. Fast forward to 5 years later, I found myself in Trademarkia, and so far, Trademarkia has been able to give me that space to actually experience intellectual property law, not just in Nigeria, but to see how it's being done in other countries. And I'm happy to be here. I've worked with Trademarkia for 1 year plus, getting to 2 years in 4 months' time. And it has been a wonderful experience. It has been a wonderful experience. I've learned a lot. I've also seen how other jurisdictions practice their IP law, and I've seen it, and I see that we need to make improvement in our own law here in Nigeria. I see how swift the processes of filing of trademarks goes, how fast you get the documents and all that. And it is something I'm still going to do, maybe in the long run, trying to use it as a template for our own laws here in Nigeria to see if our own trademark registration and other processes can move forward like other countries. So it has been a wonderful experience. I enjoy being an intellectual property attorney. I love protecting consumers. I also love protecting business owners. I feel that business owners should have and reap the economic benefit for their intellectual property work. And I also feel that consumers should not be exposed to counterfeit products, because if the intellectual property owners do not protect their trademark, other third parties will infringe on their rights, and it will expose consumers, which can cause health issues if not properly eradicated and protected. So I enjoy being an intellectual property attorney.
Well, it's great having you on the team. Could you maybe highlight some more elements, highlight strong points of your cooperation with our international team? What's the biggest international project you worked on in Trademarkia?
It will be registering a trademark in multiple countries, in over 8 different countries for a client. It was a beautiful collaboration with the international team, because not only did I get to know how their own process work, I was able to also understand the difference between our own laws and their own laws. It was an interesting experience. Like I said, I learned a lot from it, and I was happy to be on that transaction.
All right. What do you like most about working with our international team?
The fact that they are swift to respond at every given time. If you send an email to them now, be rest assured that you are going to get a response in less than an hour. In addition to that, they always explain the whole process. Like, for someone that have never actually dealt with that particular country, you are going to understand. They are able to articulate what they want from the client, and you getting relaying it back to the client. You are not going to stutter because you understood what they sent to you and all that.
So, could you highlight the essence of the recent cases you've been working, or your recent work? Is it trademark registration, or is it more protection, litigation?
Well, is to for the purpose of trademarkia is trademark protection. For litigation, yes, I've done that in the past, and because of my experience as an attorney, I've handled some trademark litigation actions.
And were these also in the fast-moving consumer goods sector?
Yes, fast moving, then automobile industry too. Yeah.
Could you tell us a bit more without, of course, disclosing any sensitive information about that these cases in the automotive sector? That sounds really interesting.
Okay, it's just with respect to their trademark name. Another company copied something similar to their own trademark. And of course, the company in question, the original proprietor of the trademark was a foreign company. They sued the other company, they brought an action. So it was a case of a manufacturer of an automobile tires who had a distributor in another country, and the distributor took steps to register their trademark outside the distributorship agreement. It was clearly stated in the agreement that they don't have the right to protect that trademark in their own country, but they took the steps to protect, and the original proprietor got to know about it and he brought an action against the company. Distributor was claiming that since he was the face of the company in that particular jurisdiction, he had the right to protect the trademark. It was still a pending action, but I know that the original distributor had chances of succeeding in that litigation. You know how lengthy litigation can be. So I was not opportune to witness the judgment before I left the services of that particular law firm.
So, in terms of your business landscape in Africa, would you say that there are certain places that are hotspots for trademark registration where business is booming currently?
Of course, I would say Nigeria for one. Nigeria is like one of the biggest countries in Africa. In fact, we pride ourselves as the giant of Africa. There are lots of opportunity in Nigeria, and I will always encourage business owners to look for opportunity to do business here in Nigeria. And the federal government have also made business, they have enacted laws and that have made ease of doing business easy for business owners. So Nigeria is a promising place for any business owner to protect their brands or to start up business here. Then in addition to that, I'll also say South Africa. South Africa is another country too that any business owner should look out to do business in. And maybe Ghana. Yeah, those three African countries.
Protect your brand with Trademarkia. Register your trademark on trademarkia.com.